when I'm reading briefs and reading cases, I'm not looking at paper, I'm looking at people. Even if I don't see them, I recognize that every case involves real people and real lives, the lawyers' lives, the clients' lives, their families. And I don't take that lightly.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and currently serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today is our co-host, as usual, Lester Tate. And today we're going to be talking about the Georgia Court of Appeals and appellate law, what that is and what it means. And to help us understand it all, we are thrilled to have the presiding judge of the Georgia Court of Appeals, the Honorable Stephen Dillard, with us today. Lester, first I'll say good morning to you. And actually, we're taping this in the afternoon, so good afternoon to you.
Good afternoon. It's great to be back here and to have Judge Dillard there. And unlike usual situations where he's been doing these Zoom arguments and he gets to ask the lawyers questions, we get to ask him questions today. Right. So that should be lots of fun.
Yes, absolutely.
Yeah. I've been really looking forward to this. We've got some good thoughts to share with Judge Dillard, and we want to hear what he has to say. He's pretty well known in the Zoom world, YouTube, the social media world. So let me tell our listeners about Judge Dillard and his really impressive career. Presiding Judge Stephen Lewis A. Dillard was appointed as the 73rd judge of the Court of Appeals of Georgia on November 1, 2010 by Governor Sonny Perdue. Prior to his appointment, Judge Dillard was in private practice with James, Bates, Pope, and Spivey in Macon, serving as chairman of the firm's appellate practice group. Judge Dillard was elected and reelected by his fellow Georgians in 2012 and in 2018. On July 1, 2017, Judge Dillard was sworn in as the 30th Chief Judge of the Court of Appeals of Georgia for a 2-year term that ended on June 30, 2019. He currently serves as the presiding judge of the court's 4th Division. Judge Dillard graduated from Samford University with a BA in 1992 and the Mississippi College School of Law with JD cum laude in 1996. In college, Judge Dillard was a member of the Sigma Chi fraternity, and in 2021, Judge Dillard was given the Significant SIG Award by the Sigma Chi fraternity, one of its highest honors, which recognizes those alumni members whose exemplary achievements in their fields of endeavor have brought great honor and prestige to the name of Sigma Chi. He is a member of the Speakers Bureau of the Federalist Society for Law and Public Policy Studies, the Lawyers Club of Atlanta, and the St. Thomas More Society. He is currently serving as a member of the Samford University Alumni Association's Executive Council and the Samford Athletic Directors Cabinet. He serves as the special consultant to the Georgia High School Mock Trial Committee. In 2019, Judge Dillard began co-teaching Georgia appellate practice at Mercer University's Law School and joined the National Advisory Board for the Constitutional Sources Project, an organization dedicated to increasing access to and understanding of the United States Constitution and its history and creation. He was also named that year as the Twitter Laureate of Georgia by the Georgia House of Representatives, as one of Atlanta's 500 most powerful leaders by Atlanta Magazine, and as best social mediator by the Fulton County Daily Report. Judge Dillard is married to Kristen McDaniel Dillard, and they have 3 children. He is an active parishioner of St. Joseph Catholic Church and the former president of the school board for St. Joseph's Catholic School. Wow. Judge Dillard, welcome to the show.
It's my honor to be with y'all. Always good to be with friends.
Well, we appreciate it and glad to, and it's also, we're doing this by Zoom, and it's also good to see you, even if only by Zoom, because it's been a long time since we've seen you.
Absolutely. Good to see y'all.
Well, the first thing I had on my agenda to talk to you about was the that award of being named Twitter laureate. Is that of all the awards you've received in your illustrious career, is that the highest one?
You know, you know how much I love Samford. I think the award that means the most to me is being named Alumnus of the Year back in 2017 for Samford. That, you know, that's the highest honor the university gives an alum, an alumnus. And so that means a lot. But, you know, I do, that was a huge recognition, a significant recognition. And a lot of my friends. And the thing that was nice about it is that it was a bipartisan award. And, you know, I mean, you know, Matthew Wilson, and I'll forget all the names and the people that were involved, but there were Republicans and Democrats. And, you know, I like to think it wasn't so much about me, maybe the type of social media presence that I try to encourage, which is one that promotes hopefully civility and education and mentoring and using social media for positive things. We hear a lot about the toxic aspects of social media, but I don't think we talk enough about the positive aspects of social media. And, you know, the things that I've been able to do, and the young lawyers and law students and people that I've been able to mentor over the past decade. I've been on Twitter for a while now. That to me is the most rewarding aspect of this. And I just got in the mail today, a very nice card from a judge on the Indiana Court of Appeals who had read an article that I recently wrote with the Chief Justice of the Supreme Court of Michigan, Bridget McCormick, who's a good, dear friend of mine. And we co-authored that article. And he said, you know, I read this, I really enjoyed it. I had stopped participating on social media, but I think I'm going to give it another try. And I thought that, you know, that's nice to know that the things you say and the things you write, that people consider those points of view and, you know, are willing to give things a shot, because I think it is important for judges to be engaged with the people they serve. And I think the best way to do that realistically is through social media platforms. So
you, as I recall, your social media presence dates back. I don't know if it was before Twitter, but didn't you run a blog when you were in private practice for a while? I mean, you've been doing this for quite some time.
I participated in numerous blogs. I did have one that I did that, you know, ranged from everything to politics to college football to a topic near and dear to both of your hearts, bourbon. You know, debating kind of the best bourbons. You know, that seems like a whole lifetime ago now. But yeah, I mean, I was a contributor to several other things. And, you know, so I think social media for me when I became a judge, it was natural, but I had to rethink. You know, I couldn't engage in the way you have to be very careful. You know, I know that y'all both know this as former bar presidents, that you have both been leaders in fighting for a fair, independent, nonpartisan judiciary. And when I became a judge, I took that responsibility to be to leave any political past I had behind and to fully embrace the nonpartisan nature of the office. And that's, I would hope that people have viewed my presence as a judge on social media platforms. They see someone that tries to stay as far away as possible from partisan politics and discuss things like professionalism and law nerd things like brief writing and oral argument tips.
Well, I was going to ask you about that, because there's a whole and you kind of stole my thunder a little bit, because I was going to say, you know, appellate lawyers are always on. There's a sort of subculture of appellate lawyers and judges on Twitter. And, you know, they're always talking about fonts, and trial lawyers like me and Robin, we're always talking about bourbon or you know, something like that. Yeah. And you know, there is, you know, for folks that don't know, I think, you know, while Robin and I have argued a large number of appeals, and I'm sure you tried a lot of cases in, private practice, but, there's sort of different cultures around different aspects of it. And it seems like this appellate Twitter handle or hashtag has sort of captured its own little subculture.
I think that's right. Although I do want to say it's a Big Ten. I mean, we've got folks in there who aren't even lawyers who participate in debates, people who just really follow some of the topics that are on appellate Twitter. And I like appellate Twitter. I like law Twitter. I like trial lawyer Twitter. I think it's interesting. One of the great things that I think has really transformed me in many ways. One of the downsides of social media is that there's that immediacy to it. And, a lot of us, I think it's not just a few people, but a lot of people, there's that kind of immediate gratification of putting something out there or responding when something happens and, getting feedback. Sometimes even if it's negative, just kind of engaging and battling. And, the one thing being a judge has done for me is it's forced me to listen a lot more. And because of the nonpartisan nature of my office and because of the type of content I try to put on social media, in some ways, I think it's my timeline has become what I hope is an oasis from some of the toxic political debates of the day, where we can nerd out over fonts, or we can talk about our love for M dashes or semicolons, or we can talk about music or football. Now I can get passionate with football, but I think it's a good. I think there can be communities, as you pointed out, Lester, that are built, and there's mentoring that goes on there. There are referrals that go on there. It really is. I say judges ought to be on social media. I think lawyers. It's good for lawyers to be on social media as well. I mean, if you use it correctly, I think it can be a very positive thing. But for me, it forced me to listen a lot more, which is something I needed to do. And because I've been forced to listen, and because I can't comment on the news of the day, I think I've grown as a person because because I'm listening now and not commenting right away. I'm hearing viewpoints that I maybe didn't hear as much or didn't hear as thoughtfully before because I really wasn't listening. But that's something that I've really benefited from social media. Is my timeline has, if you can imagine the farthest, end of the left end of the spectrum and the farthest end of the right end of the spectrum, all people follow me all along that, that spectrum. And, I like that. I think that's
so. Why do you think that? Because I'll just tell you, and I don't. Robin's on Twitter. I'm on Twitter, but I hadn't seen a lot of trial lawyer Twitter. It just doesn't seem to have that following. What is it you think is sort of special about appellate lawyers and judges that have grown that subculture the way it is?
I just think we're nerds. I mean, I think it's, we're just nerds and we like talking about nerdy things. And we have very few people in our lives that want to talk about M dashes or semicolons or, different aspects of brief writing and, topic sentences, transition words. I mean, and then when you find a group, that really immerses, the collective members, we all immerse ourselves in research and writing. It's nice to have sounding boards and to learn. I learn new things from judges and lawyers all the time. You've got Brian Garner, Ross Gruberman. I mean, you've got all these legal writing experts who are on there. I've got like Orrin Kerr, who's one of the, most prominent Fourth Amendment scholars in the United States. And I can follow him and I learn. I mean, I have cited his stuff in some of my opinions. So it's really, like I said, if you do it the right way, I think social media can really be a positive force. It can be, there's a downside too. And I've experienced some of that as well, just in the sense that I think the bigger your account gets, the more you bring in people that really aren't interested in kind of engaging in good faith dialogue. They're just there to kind of, be snarky or say something mean. And, that if you're a public figure, you just got to let that roll off your back.
I've heard you, Judge Dillard, talk in other places that social media helps you as a judge who has to be held accountable by the citizens of Georgia because you have to run for election. There are some states where judges do not run for election. Georgia is one where our judges do run. And as I noted in your introduction, you've run for reelection twice. So tell us a little bit about how you use social media to reach out to basically Georgia constituents.
I think, the first thing I'll say is, I've often heard it from journalists and others and citizens that we don't know enough about our court system. We don't know enough about how courts work. And so I've used some traditional means to talk about the day-to-day work of the Court of Appeals. In addition to writing my opinions, I've written not one, but 2 law review articles on the inner workings and cultures of the Court of Appeals that are published in Mercer's Law Review. And I did that for, primarily lawyers and trial court judges and even some folks on the Supreme Court. But also, if anybody calls my office, I'm happy to email it to them for free. But I wanted to do that because I think, before I joined the court, a lot of how we operated, to me at least, as a practitioner, was shrouded in mystery. And I just didn't think I don't know that was intentional, but it just struck me as not being right. I mean, we're public servants. We're not black robe philosophers. We serve the people. And I felt like it was important for lawyers and trial judges and everyone else, anybody who wanted to know about, not specifics about cases, but just how an appeal works its way through the appellate process at the Court of Appeals. And so, that's one way I did it. I've shared that article many times, and I'll probably share it again recently as we're finishing up our distress period here. We can talk more about that later. But, I've done town halls, kind of, Q&As where people can ask me questions about oral argument or brief writing. Once again, I can't talk about specific cases, but, and look, is everyone interested in this stuff? No, probably not. But to me, what's important is that the more I do things like this, these things are out there on, on the internet. And we now have live streaming of oral arguments, which we didn't have for a while. That was kind of my baby. Obviously, my colleagues, I'm very thankful for them for agreeing, but it took me about 5 or 6 years to convince, as we had some turnover, to convince my colleagues to live stream. I'm very proud of that we were able to do that even before we moved into the new building. Once again, or do we have thousands of people watching our Court of Appeals, our oral arguments? No, but the thing is, they're there. They're there, and not only can people watch them live, we've got archived oral arguments going back to when we started in September of 2016. I just believe, with everything I have at my core, that we are public servants, that we serve the people, that we should be transparent in how we operate, that we ought to educate the public about what we do as much as possible. And in addition to all that, talking about things about, intricacies of our Georgia appellate system, I think it's not a bad thing for people to recognize that underneath that robe is a human being. I'm a father. I'm a husband. I'm a proud Sanford graduate. I'm a person of faith. And while those things don't drive my decision-making, they do often drive how I explain things and opinions, how I write, my voice. And so I think, to me, I want Georgians to have access to that information. If they choose not to use it or they choose not to follow me on social media, that's fine. But I want to feel like I've done everything I can to it's not so much about me, it's really about the court system. But to the extent they want to know about me, you guys are friends with me. You've seen my Twitter feed. It's pretty much who I am. I don't, obviously you put your best foot forward. And I mean, I have my faults just like anybody else, but I think my social media presence is a pretty accurate reflection of who I am as a person.
So Judge Dillard, you mentioned the taping of oral arguments that we can now watch. Actually, we can watch your oral arguments in the Court of Appeals live. And then they are on the Georgia Court of Appeals website, which I think is gaappeals.us. Is that right? And I can remember, because I've been around a little while, not quite as long as Lester, but maybe a little bit longer than Judge Dillard. But I remember when you couldn't do that, and I advocated for putting them online so that the folks in Savannah or Valdosta who wanted to watch an oral argument didn't have to drive 4 hours to come and watch for 30 minutes. So, and I'm going to give credit to you, because the Georgia Court of Appeals started doing that way before COVID. COVID really didn't have anything to do with it.
2016 is when we started it, and it took longer than it should, in my view. But things happen incrementally, and that was the fight that I had to. And I don't want to say it was all me, because I had a then Chief Judge Doyle. I did this when I was vice chief. She was supportive of me. She wasn't crazy about it, I don't think, but she understood where I was coming from, and I think my colleagues did too. Now nobody questions it. Now it's. Everybody's like, well, of course we have live streaming of oral arguments, but it was tricky with the timing of the building, and I had to go across the street and kind of argue to the legislators, even though we know we're getting a new building, it's worth the money for the next 3 or 4 years for us to do this. What is it worth $80,000, $100,000 for 4 years for people to have access to their Court of Appeals? And they agreed with me. I appreciate our legislators, and we, especially some of our lawyer legislators who, championed that. It wasn't a lot of money, but it's one of these small things that I think has had a big impact, especially for lawyers who don't live in Atlanta. And as someone who practiced outside of Atlanta, I kind of came to the court with the heart of a non-Atlanta practitioner. Not that the Atlanta lawyers are awesome, but they have, you did, I think, prior to a lot of this technology, you did feel like sometimes you were at a disadvantage, or you had to work harder because of the distance from Atlanta.
Well, it is more, to me, watching an appellate argument is more informative and more interesting than like watching a legislative session, because there's just a lot of sort of downtime and bill reading, and now they have hymn singing and pledging and all this other stuff going on. But if you want to see how the government works, like what it is, you get 20 good minutes, watching an appellate argument. But the one place, and I'm going to put you on the spot a little bit here, but
Sure.
one place that we still don't have that is the United States Supreme Court. Right. And I saw the other day where I think the Senate Judiciary Committee marked up a bill to mandate, televising oral arguments in the Supreme Court. How do you and appellate Twitter feel about that?
Well, I can only speak for myself. That, I don't talk about politics, but this is probably the furthest I've gone out on the ledge. And I've said a few times on Twitter that my hope is that I have encouraged the Supreme Court justices to allow live streaming. I like to say judges are different, but we're not special. And that's the only area of our government, and it is the highest level of what we do, certainly as to federal law. And I just think the arguments against live streaming, that they'll be taken out of context. They're already taken out of context. They're taken out of context even when they don't have video. You're a public official. You just have to live with that. I think the educational benefits and the civic benefits of allowing those arguments in real time and allowing us to see the practitioners and the justices, I just think that's invaluable. And I don't think there's a very compelling case for not allowing it. I will say, and maybe this is the institutionalist in me, and so I may be biased in this respect, I do not like Congress forcing the Supreme Court to do it. I think they can incentivize it. I would rather the Supreme Court come to this conclusion on its own. I think sometimes when legislators interfere with how courts operate, in this case, it may seem like a good idea, but then the question is, how much do we let them? I do think there is something to be said from kind of a separation of power standpoint to let courts decide how they're going to operate. Now, maybe there's an occasion here the public interest is great enough, but I won't go as far as to say I support Congress forcing them to do it. I encourage my fellow jurists on our highest court to do the right thing and to allow live streaming of their arguments. I think the benefits of it are just tremendous, would be tremendous for civic engagement, civic education, and transparency. Once again, a lot of what they do is shrouded in mystery, and I don't like that. I don't think the law belongs to the people. I don't think it should be mysterious. I think it ought to be accessible to the people.
I totally agree. And now during COVID, they are doing real-time telephone or audio only hearings, and it would be so much more compelling if we could see the folks argue as they do it. So maybe they're just taking baby steps and they'll get there. I'd heard one excuse for not doing is they were afraid the lawyers would grandstand on camera. And from all the oral arguments I've seen in your court, that just simply does not happen. Do you agree?
I agree. And I think most of the arguments at that court are by very skilled specialist lawyers. And the idea that Paul Clement or, any of these frequent SCOTUS advocates are going to grant, I don't buy it. I don't. And even if it happens, I'm confident in the ability of the Chief Justice to tamp that down if necessary.
Yeah. Now, Judge Dillard, we've often heard that your court, Georgia Court of Appeals, is the busiest appellate court in America. Judge Ellington, when he was on your court, he's now on the Supreme Court, but he used to always go around when he would talk and give talks and speeches that it was the busiest court. Is that still true?
I don't know it's hard even when, certainly when we were 12 judges, I think if we weren't the busiest, we were so close that us making that claim was not a stretch at all. I think now with 15 judges, we are still, I've heard comparisons like to Ohio and Louisiana, where we roughly have the same caseload, but they've got 60, or 50 judges, and we've got 15. So even at 15, we are, we're doing a lot. Georgia's getting a lot of bang for its buck with its state intermediate appellate court. I don't know that we're the busiest, but I would put us well within the top. I would say we're well within the top 5%. I still think we are an extraordinary, we are a small, when you think about the fact that we are what I would call, how you talk about a strong mayoral system, we are a strong intermediate appellate court. We are unified in geography. So unlike Florida, our intermediate appellate court is not divided up, or Illinois divided up into divisions. We are unified in subject matter, unlike Alabama. We don't have a criminal intermediate appellate court and a civil appellate court. And so, and we are the final say in about 85% of all appeals. And even, and the thing is, when we had the law in 2015, 2016, where we did the Appellate Jurisdiction Reform Act, where we shifted cases that had traditionally jumped us and gone to the Supreme Court, like divorce, title to land, will contest, equity, kind of mandamus cases like that. Those all got shifted down to us. We actually became that made us even more of the court of last resort and made the Supreme Court more of a certiorari court, or certiorari, however you want to pronounce it. But I think, that's the thing. The Court of Appeals, both courts are extremely important. The Supreme Court of Georgia is extremely busy, even with the 9 justices since they've expanded. But in terms of like the impact on the average citizen in Georgia, we have in my view, have a far greater impact just simply because of the number of cases where we are effectively the court of last resort. 85% of all appeals in state appeals in Georgia end at the Court of Appeals.
So
Especially when you took on the divorce cases, you have jurisdiction over those. That I assume that really increased your caseload.
It did. I mean, it's interesting. It did in some respects, but in other areas, things leveled off a little bit. So, we're busy. When I got on the court, we weren't just busy; it was insane. I would the comparison I would make is the Supreme Court of the United States takes about 79 cases a year, 80 cases a year. We have our distress deadlines. We have these 3 deadlines every year that we have to meet those deadlines. We got one coming up this Friday. We have to get our cases out, or they're affirmed as a matter of law. That's under the Georgia Constitution. My first Jan term, which is now called the winter term, I had roughly 72, 73 cases that had to go out the door in 3.5 months. I mean, that's just me that I had to write. Then I had to review about that many from the 2 other members on my panel that had to review motions and orders and whole court cases. And back then, what were backup panel cases. I mean, it was insane. You were triaging constantly, and that was no way to run a railroad. And that's why when we did the Appellate Jurisdiction Reform Act and we gave the authority to decide how we decided cases, took it away from the legislature and gave it back to the Court of Appeals, we reformed our system. And now we do have cases that go down to the wire, but it's much more manageable now than it used to be. And with the expansion of the court from 12 to 15, that spread the caseload out. So we're still busy. I don't want anyone to come away from this conversation, but there's a difference between being busy and just not having enough time to really write the kind of opinions that provide clarity and thoughtfulness to the body of case law in Georgia. Now I think we're in a position to do that. And it was hard. You could do it, and I did my best to do it while we were under the old system. But, I was working, and I still do, but really, really working a lot more hours than I did in private practice. I worked every Saturday and Sunday. Now I still work on the weekends, but it's not insane like it used to be.
So in comparing the Georgia Court of Appeals to Court of Appeals other places, by the way, we mentioned my friend John Ellington. I just want to say I never said that John left the Court of Appeals and went to the Supreme Court and improved the average IQ of both places. I just want to be clear about that. But I went to law school at the University of South Carolina, and I think the first time I ever actually went to an appellate court, it was to the South Carolina Court of Appeals. At the time, there was a renowned lawyer, former president of the College of Charleston, now chief judge, named Alex Sanders, and he became the chief judge. He was the first chief judge in about, I think, 1980 or so. And one of their traditions was that after they heard an oral argument, they get up, they leave the bench, they go into a room, sort of like a jury room, off the thing, and they sort of take a preliminary vote and they briefly discuss the case. Then they come back and hear the next one. If I understand the Georgia Court of Appeals procedure correctly, that's not part of it. And in fact, there's not really a time to where all the judges deciding it are necessarily advocating their position orally to one another. Is that true? And how do you feel about that sort of difference?
I think it's less true today than it was when I joined the court. A lot of, there would be some discussion, although some judges, when we got off the bench, in my early years, they just didn't want to talk about it. Their views were, I'll submit the case when I submit the case. When I became a presiding judge, I was like, well, this is my division as the presiding judge. I get to kind of decide how to do this. We don't do formal conferencing. A lot of our cases aren't a lot of them are not controversial. They're fairly, they're important appeals, but they're fairly routine, and the outcome is fairly obvious. And so in those cases, I don't know that sitting around in a room, because we do have to manage our time wisely at the Court of Appeals. I don't know that just kind of going through, every one of those and describing them and then kind of, when the outcome's obvious. But when we have oral argument cases, what we do And obviously it's had to change a little bit with the pandemic. And so we wait till the recording's not going, and then we really make sure that it's not going out to the public. And then we'll stay on Zoom right now and confer. We usually have a kind of post-oral argument. We don't do it after each argument, but we will do it after all of them are over. And then the judge that is assigned to that case will usually say, here's kind of my thoughts on this case. What do y'all think? And it's a little less formal, I think, than the South Carolina, what you're talking about, or certainly the type of process that went on at the Seventh Circuit where I clerked with my judge, Judge Mannion. But there is conferencing that goes on, and there are considerable discussions that go on too, both with regard to oral argument and non-oral argument cases throughout the term. I'm on a panel right now with Mandy Mercier and Verta Colvin, and we have had numerous conversations throughout the term about cases. Sometimes it's in person, a lot of times it's been by phone. Sometimes it's by email, but we are in constant communications about our cases. So there is conferencing that goes on. I think it maybe just is a little less formal, and some of that just may be because of the nature of the caseload, finding a day where we all just kind of sit down formally. I think this is how we've done it. But I will say in the past, when I got to the court, there was a lot of memos that would go back and forth. The problem with memos, in my experience, is you can't always, when you're doing those things quickly, you can't always do a good job of controlling the tone. And sometimes something that you don't intend to be snarky or curt can come across that way in a memo. Whereas if I come to your office and sit down with you, Lester, and you're on my panel, let's say you're on the Court of Appeal, or you or Robin are on a panel with me at the Court of Appeals. If I, say, hey, let's all go out to lunch, or hey, I'll bring lunch in. And we've done that sometimes. Or if I come to your office, Lester, and I say, hey, here's the issue I have with the opinion you wrote. That's going to be taken differently than me writing you a memo where I really may not have time to kind of think about, or an email where I may not have time to think about tone or the time to make it sound better, if that makes sense.
I think it does. And it could be read like a tweet. When you're sending a memo around, you don't control the tone all the time.
Judge Dillard, you've mentioned a couple of times this mysterious thing called distress.
Yeah.
And I believe you're referring to a period of time, and I actually don't know, is it long or it's a certain period, number of days?
1 month.
Before all opinions within 2 terms of court, the last 2 terms of court, have to be issued. Did I get that right?
That's correct. And we really do what's called an artificial deadline, because we have to build in 10 days for motions for reconsideration. So, I think technically the end of term for the Court of Appeals for what is called the December or winter term that we're in right now, all the cases must be out Friday, but the real deadline is like a little bit before the middle of the month, because we build in that motion for reconsideration period. But we're in distress right now. So we started when we got 30 days out from this Friday. The minute things start going around, they're labeled, granted in emails, this is a distress case. We put that in the kind of the subject matter line of the email to let people know, I'm not sending you a case for next term. This is one. So, as the judge, you need to prioritize it.
And that is a Georgia Constitution mandate. Is that correct?
That's correct. It is the 2-term rule in the Georgia Constitution. It means that we have to get cases out 2 terms from the date of docketing, and we have 3 deadlines a year. One is this one, which is kind of the end of June, early July. The next one will be end of October, early November. And then the one after that is middle of March. And they're all roughly 4 months. This one's 3.5. This next one's like 4. And I think 4.5. And the one after that's like 4 months.
Yeah. So to a lay person who would hear that you have a period of time called distress, that you're getting out these opinions, distress, I understand that's what the judges use to describe that period, because you're under the gun basically. But I'm wondering if lay people have a lot of confidence in opinions issued during distress. That gives me I'm a little worried about that.
Well, efficiency has its consequences, right? I mean, we love the 2-term rule because it requires us to get cases out. You know that if you are in the state of Georgia and you're a citizen or you are a lawyer, I'm telling you now, you will have your decision most likely at the outer end in about 8.5. I mean, usually about 8 months at the max, probably before that. So that sounds like a lot of time to folks. But when you consider there are appellate courts where appeals have been languishing for 5 years, now that's extreme, but it happens. It's a pretty great rule. One of the reasons we reformed the court is so that we would really be able to put judges in a better position to finish their work on time. So it could be that the case that comes out on the final day of distress was actually circulated. And we have one that came out today that actually circulated a month ago. But if it's a whole court case with 15 judges, it may take a month to go through 15 judges because a lot of judges like to write and they want to, put their own stamp on the case or a concurrence or a dissent. Or it could be a 3-judge decision where one judge held it for a long time because they wanted to think about it. So it's not always the case that an opinion that comes out toward the end or during that 30-day window of the distress period, especially toward the end, it's not always the case that case was rushed, but sometimes it is. And that's why I tell people, if you get an opinion and maybe it's not as in depth as you would like, or you think there's problems with it, I would say it's always difficult to get an MFR granted at the Court of Appeals, but your best chance is probably during with cases that fall within that last couple of weeks, because not all of them are going to be that way, but some of them, it just may be that you got the opinion late and you just, I don't care how smart you are. This is the same for lawyers. Robin, if you give an assignment to an associate and you say, I want this brief and we've got to file it in 30 days, and they give it to you on the 29th day. Now you're very smart and you're an excellent writer. But and you're not going to let this happen, but let's just say hypothetically it did happen. You've only got a day to really think deeply about that brief and to go look at the research and do all that. You're going to do your best work and you may pull an all-nighter to get it done and get it filed. But no matter how smart you are, there's something to be said for letting things marinate and putting things to the side. And so if you're a judge and you're not writing the opinion and I get it with 6 hours to go, there's only so much I can do with that because I've got to meet that deadline. So I think we've gotten better. There were some times early on in my career at the Court of Appeals where I was getting things literally 1 or 2 hours before they're going out the door. And back then we had paper records. So you might be able to read the briefs, but you didn't get to see the record until it came to your office. I mean, it was not a good system. And so I'm glad we've reformed it. I think things are a lot better now. I think lawyers and citizens should have a lot more confidence in this new system, the way we've designed it. But it's still the case that human nature is such that the hardest cases often get pushed toward the end. And maybe those are the ones that are more ripe for reconsideration. So that's what I would say. I think all my colleagues do the best we can. But sometimes, you get that one case that's got 50 boxes and you've got 40 other cases to get out the door in a 4-month period. That, once again, efficiency has its price, and the 2-term rule is wonderful, but there are some downsides to it. And I think all of our judges at the Court of Appeals are doing the best they can to do the best work they can under the timeline.
So, I was thinking too, when you were talking about distress, for a trial lawyer, that sounds like the week before you start the trial,
right.
Which is sometimes sort of the beginning of the appeal too. But how do you decide an appellate case? Do you go read the briefs first? Do you get the order first? Do you read the record and then go, kind of form your own opinion about it? Or how do you do that? And in particular, and I know there are different standards of review for different cases, abuse of discretion and,
Right.
against the weight of the evidence or whatever else. So I'm not really asking this question in a real technical legal sense.
Sure.
But do you start sort of from a general presumption that the judge knew, he or she knew what they were doing, below?
I think, I don't know that I start with that presumption. I start with the presumption that standard of review matters greatly. For me, one of the things I try to do in every case is apply the same approach to every case, regardless of who's involved, regardless of what kind of case it is. And, appellate courts, really do two things. And I'm talking at a very general level. Appellate court, to me, justice, because we're going to talk about justice in a little bit. I know that I've been warned. We're going to talk a little bit about justice in general. But to me, justice in ideal circumstances happens at the trial court level. Appellate courts, to me, should be backstops. We are there to ensure not that everyone gets a perfect trial, but that everyone gets a fair trial. So we're a backstop in a sense for things that go on at the trial level on a statewide basis. We're also there to be kind of guardians of the case law to make sure that we're providing case law that is instructive, that's clear, that gives guidance to the bench and bar and to the people in terms of how they can, and businesses in terms of how they can, just live their lives and go about whatever they want to do with their lives. And so that's kind of what we do. So when I'm looking at an appeal, my process, interestingly, kind of, I don't know if this is just the nature of how I operate. The standard review is obviously a big thing. Obviously, I read the briefs. In some cases, I'll look up the record because it's all online now, and I may start with the order. But it just kind of varies. Sometimes I start with the reply brief. I don't know. I try to shake it up a little bit because I'm fearful of getting into patterns of doing the same thing in every appeal. And so sometimes I'll look at it. I'll try to just flip through things and get a general sense. And then I'll be like, okay, I think maybe the reply brief's the place to start here. So I'll read the briefs. I'll read through the record. I'll usually at that point have a draft opinion from my staff attorneys. If it was a difficult case, I'll probably have had 3 or 4 or 5 or more conversations with the staff attorney as they were drafting the opinion. And then I take all of that. I open the Word Perfect document where I'm working on the opinion as I go. And sometimes I'll put notes in there for myself just to make sure. I want to make sure we're addressing all the arguments fairly and honestly. I don't like, if you make 7 arguments, I may dispose of some of them in a footnote, but I like to kind of acknowledge all of the arguments in an opinion. And then I just kind of go through the process of reading the cases, getting an understanding of whether it's the statutory law at issue, whether it's precedent at issue. And then just, I'm trying to go about it. And like I said, when I get it, my staff attorneys know my general approach, but my charge to them is always, our job is to get it right. Our job is for me to be the judge, not to simply pick winners and losers and what I like. And that's how I go about it. I mean, I'm trying to apply neutral principles in every case, apply to the law, to the facts, and get to the right answer or the best of maybe a few plausible answers. And that process is sometimes it's not hard and sometimes it is difficult. And, what I always tell the people, that I talk to, whether lawyers, judges, or anyone else, I'm going to try to do the best I can in every case. I'm not always going to get it right, but I do want to be consistent in how I approach each case.
Talk to us a little bit about when you're reviewing other judges' opinions that you have to sign off on, how you decide to write either what's known as a concurrence or a dissent. And why do judges write those things?
I think on a concurrence, it may very well be that I read, let's say, an opinion from Judge Mercier, and I read her opinion and I think, this is well written. I think she's right on the law. Or I think she's right about part of the law and I think the result's right. but she doesn't discuss this. And to me, this is a stronger basis to rest the decision. It may be that she's right about what she's basing the reasoning on, but I would, or maybe she's got 2 or 3 things, and I would only rest it on one. Like I'm like, you don't need to reach A and B. We can dispose of this case simply by relying on C. And I don't think we ought to be commenting on this dissent. I write when I just think not only the reasoning is problematic, but the outcome is wrong. And I've interestingly, I think when I got on the bench, a lot of people would have been like, Dillard's going to write dissents all the time. I've not written a ton of dissents. I've written a decent amount over 10 and a half years, but I would be surprised if I've written more than 15 or 20 dissents in 10 and a half years. I've written a lot of concurrences. And I've written a lot of concurrences dubitante, which is a fancy Latin way of saying concurring fully but doubtfully. And sometimes I've done that where I felt like my hands were tied, that I couldn't reconsider the precedent, but that I thought it ought to be considered. In other words, saying this is what the law is currently, but I don't think it should be. So I've done that a few times too. That's something that my friend, now retired Justice Blackwell, he kind of brought that back into fashion at the Court of Appeals, and I kind of took it and ran with it because I like it. I like being able to say, I'm going to go along with this. I'm going to follow it because I think it's the law. But I think judges have an obligation to do that. I think we ought to critically, just because something is the law doesn't mean that it ought to be based on the law. In other words, not because I just don't like it personally, but because I've looked at the statute and I think we've just been misinterpreting it for a really long time. But I'm bound by the Supreme Court precedent. I can write a concurrence and say, Supreme Court says I have to rule this way, but I think they ought to reconsider it. And I think that's how we clean up the law, through concurrences and dissents and things like that. One of my first dissents, Robin, was actually an 11-1 case where I lost. We only had 12 judges at the time, so I lost 11-1. Even Blackwell didn't go with me. And the views of that dissent that I filed early on in my career, a lot of that is now the majority view at the court.
That's what I was going to ask you. I don't know if you keep stats, but I was wondering, have you ever seen a dissent? Maybe you're writing for the Supreme Court of Georgia saying this is the way it should be. It's not the way the law allows it, but this is the way it should be. Do you ever look to say, hey, they adopted my dissent?
Oh yeah, I keep score. I watch. I
wondered.
I've had several dissents that have become unanimous Supreme Court opinions. You asked, I'm telling you.
No, I wanted to know if you kept up with that. Let me ask this other question before Lester asks a question. But in the same vein, when you are reversed, do you keep up with that?
I do.
Keep stats on reversal?
Here's the thing. It's not so much keeping up with it as to, go up and, harass my good friend Justice Boggs about it. Although I do that every once in a while, after everything's said and done. But no, I think it's for a learning opportunity. If they reverse me, I typically will have conversations with my staff attorneys. And sometimes we just come to the conclusion that, sometimes the Supreme Court just wants to do something different. It had nothing to do with my opinion. Sometimes they think I just got it wrong, and I respectfully disagree. But I do think those are learning opportunities for us to kind of critically examine, is there something we missed? And occasionally, hasn't happened often in 10 and a half years, but occasionally they'll reverse me. I'm like, okay, I can see that. I can see where they're coming from. I don't know that I completely agree with it, but I see where they're coming from. And sometimes it's just a difference of opinion in how to read a precedent. I'll read one of their precedents and feel like I'm bound by it. That's normally where I get in trouble. Interestingly, it's when I follow an older Supreme Court precedent that I think I'm bound by, and then they write an opinion and they're like, well, that's not really what it says. And I'm like, yeah, it kind of is. And they're like, no, that's not what it says. So you didn't have to follow that precedent. That's when I've gotten reversed. It's usually because I followed an older Supreme Court opinion that I thought I was bound by, and they said I wasn't.
So my question is, does oral argument really change anybody's mind? And I'm going to kind of go off the reservation here. I watched we were talking about the U.S. Supreme Court, the UK Supreme Court, the British Supreme Court has had cameras, and they had fascinating oral arguments over different aspects of Brexit, where a barrister appearing there would have 2 hours for his presentation that he would make there, where I don't know of any appellate court in the United States that gives more than 30 minutes at the outside, would be the upper end. And so, I mean, they clearly have a much more oral tradition of advocacy maybe than we do here. But I will confess, and this was I've been doing this 35 years, so this would have been in my earlier years, but I confess to having gone down to the Court of Appeals or the Supreme Court from time to time and feeling I should have taken a mirror to sort of hold up and see if it fogged, to see if the judges were breathing, while they were sitting up there, because there were no questions. There was no, it's very conscious, I think, to folks like Robin and I who frequently try jury trials, where you kind of get a little feel, from the people you're presenting your case to, one way or another. Right. And I think I think that aspect's changed too, by the way, recently with both the Georgia Court of Appeals and the Supreme Court. But, does oral argument really matter?
I think it does. I think it matters. And I give some of these reasons in my Mercer article. There's 3 reasons why I think it matters. Number one, I think it matters for professionalism purposes. And one of the things, I think we may have even amended our rules to say this, is that, even in a case that may be more routine, if you basically point out that you're going to give a young lawyer an opportunity to make their first appellate argument, we're more likely to grant those if you put that in your request. So I think it matters from a professionalism standpoint. I now that things our load is light, that I'm granting more oral arguments than I have in the past, although I've probably always been more active in granting oral arguments. I think the other reason it matters, once again, is for transparency purposes. I think holding oral arguments, especially when you live stream them, not holding oral arguments is not really giving a window into the judges and their approaches to the law and how they handle cases. And the only way you can really witness that publicly is through oral arguments. I think it matters. Now, as to your point, does it matter in terms of the decision making? I think it can. One of the benefits of oral argument at the Court of Appeals, because we do have the 2-term rule, while I do spend a good bit of time preparing, I can't spend the amount of time that I did helping Judge Mannion prepare for federal arguments, because we don't have the Army, the Central Staff Army that they did, because we're trying to get cases out for the current term. Oral argument is always next term. So it's a lifetime away. So I do prepare for oral argument carefully. I read the briefs, I read the relevant cases, I get what I consider to be the relevant parts of the record. But the lawyer should always, whether it's in the state system or the federal system, always be more prepared than the judges. And so when I come to oral argument, I have had cases where I went in, kind of with an initial, this is how I think I'm leaning, and had that go away. Now, most of the time, my gut reaction is the right one, or how I come out, whether anyone else thinks it's right. It's how I come out in the case. But here's the important thing. A good oral argument, and you guys know this because you're both very good at this, a good oral argument is where I walk away from that having felt like I had a conversation with a knowledgeable lawyer about the facts and law of that case. And even if I rule against you, that conversation is going to help me in how I write that case. I go back and watch oral argument cases, whether I'm the author or whether I'm just simply a voting judge on that, because it's amazing how much it refreshes my memory of that preparation process that I go through. So I think oral argument is very useful, and I think it's important to have that, and it's a unique opportunity for the lawyer to really, if I'm heading down the wrong road, to kind of bring me back. And like I tell a lot of lawyers, there's losing and then there's losing, and sometimes it may be that you lose at the Court of Appeals, but you lose in a way that makes for a better cert petition, if that makes sense. And so I think oral argument matters greatly. I don't think it's just for show. I think that part of it's important in terms of transparency and accessibility and kind of displaying that to the people of Georgia. But there are, I think, as a judge, my experience has been that I always benefit in some way. It might be smaller or bigger in a particular case. I always benefit from oral argument, almost always, in some way.
Losing is losing, no matter how you cut it, Judge. I'll just tell you. And I've been on my share of the losing end, so I know what it's like.
But if you're losing, makes for a better cert petition in a certain way.
It's still.
Fair enough.
It still is not fun. Let's talk a little bit about what you would call your judicial philosophy. We hear it's kind of hard to understand some things about jurist, appellate jurists, but we hear things like strict constructionist, originalist, textualist, and there may have been a United States Supreme Court justice who you sort of write like or pattern yourself after. I don't know. You may want to talk about that. But if you in the world of judicial philosophies, where do you fall?
I certainly, I would say I'm a judge first and foremost, and I'm a judge. I don't have any problems with saying that I'm an originalist and a textualist. I don't know. The problem with labels is that I think they've become so politicized that they don't accurately convey. Like, as far as originalism, there's very little originalism that I'm going to do at the Court of Appeals of Georgia. There's just not opportunities for that. I mean, I can, it may matter in the sense of concurrences and dissents that I write on occasion, but that's really rare. For the people that are really kind of reading my opinions, I think textualism is, I'm a textualist. I care about what the words of the laws or regulations or ordinances, what those mean. I don't speculate about what they might mean. I don't speculate about what I think would be a better law. The political fortunes of the people under the Gold Dome, they come and go. You might have Republicans in control at some point. For many years, the Democrats were. If the legislature passes a law and it's signed into law by the governor, whatever it is, I'm going to try to faithfully interpret the words of that law and apply it to the facts of a case. Now, if that makes me conservative, then so be it. I think it makes me a judge, which is why I think it's a little weird to say so-and-so is a liberal judge or so-and-so is a conservative judge, especially when in most cases, Ann Barnes and I, who might not always see eye to eye on everything, are probably going to vote with each other in 98% of all the cases. Now, how I write an opinion may differ from her, and the things I emphasize may differ from her, but we're going to agree on most cases and most outcomes. For me, put the labels aside. I think what you have to ask yourself is, what kind of person do you want as a judge? Do you want someone that's going to say, this is how I think the case ought to come out and reason backwards? Or do you want a judge that is trying to put their personal policy preferences aside and look at the law using neutral principles or neutral parameters to operate within and say, here's what I think the answers are? And I'm not saying there's always one right answer in every case. In a lot of cases, there is one right answer. In some cases, there's maybe a spectrum of right answers, and some are better than others because the law is not always going to be clear. But to me, the question is, what is that judge attempting to do when he or she decides a case? And for me, I'm engaging in problem solving. That's what I'm trying to figure out, what the law is, using tools, whether it's the rules of statutory construction, whether it's analyzing precedent that may not always be clear. I'm going to try and engaging in what I like to call judicial restraint, and not jumping out in front of the law or infringing on territory that probably more rightfully belongs to the Supreme Court of Georgia, and respecting their role in the Georgia judicial system and having judicial modesty. And so all of those things, it's not, when you start saying originalists and textualists and all this, or living constitutionalist or strict constructionist, which I am not, by the way. I don't believe words should be strictly construed. I think words ought to be reasonably and fairly construed. And even Justice Scalia rejected the term strict constructionist. So for me, whatever the labels are, to me, it's about being a judge. And it is about being someone who is trying to faithfully interpret the law written and enacted by the people's representatives. That's my job.
So I want to touch on something you said there, and at my office we have what we call Lester's Law, and that's when in court, if you're explaining, you're losing. And I think one of the things that you talked about is do judges that go to the end and say, I want this case to come out this way. And how am I going to get it to come out that way? And as a trial lawyer, I just sort of detest that, And one of the ways that I feel like I see that happening, and there are a lot of nameless judges that I could name that, I feel maybe engage in that practice. But one of the things that I think is just a hallmark of it is a lengthy opinion. The longer you have to explain why you're coming out where you're coming out, the more suspect it is in my mind. Do you agree or disagree with that?
Well, as the author of some lengthy opinions, I will partially dissent. I think there's a couple of things. What's the old saying, Lester? Was it Ben Franklin who said that if I'd had more time, I could have made it shorter?
Right.
Part of my view is that one of the reasons why we often have lengthy opinions is we just do not have the time under the distress rule. And I don't want to throw everything under the distress rule, but I can't emphasize enough how much of our culture is kind of inextricably intertwined with those constitutional deadlines. And so I work hard to try to write relatively short opinions, but there are some cases like, I had one a while back that was this EMC case, and it was really, there were numerous claims and like all these briefs and amici and sometimes you just don't have a choice because the downside of not thoroughly addressing everything is that some people, I don't ever want lawyers to walk away from a case thinking that I did not fully address their arguments. And if that means sometimes I err on the side of writing a lengthy opinion, I would rather do that but I mean, I also try to cut as much as I can.
And I'm not letting lawyers off the hook here either. I'm not just picking on judges. Yeah. I've always said that the most difficult lawyer skill to learn is when to shut up. Right. And I think the last time I argued in front of the Georgia Supreme Court, I got a unanimous victory, and I'd reserved about half my time to respond, but I could sit there and I could count votes with the questions that got asked. And so I didn't even use any of my time, but it pained me because lawyers like to get up and talk. And so I think all of those are, like I said, maybe sort of little clues, but certainly not dispositive. And with a complicated case, you owe it to the parties to address all the issues too.
And sometimes the law has gotten out of whack. Like, my first dissent that I wrote that I referenced earlier in the termination of parental rights context, we had gone really for a really lengthy period of time with, I think, any critical analysis of our termination of parental rights jurisprudence. And so it took me a while. It was about a 58-page dissent, but I kind of went through and explained the trajectory of how we got to where we were and why it was wrong. And sometimes that takes time, but I think your point's well taken. I think, what you want to strive for is to put out opinions that, anybody off the street could read in about 15 or 20 minutes, or really preferably 10 or 15 minutes, and be able to understand it. And so the longer you go on the more, I think, from an accessibility standpoint to the people and to lawyers, I think it's not ideal. I'll just say that. But you know as a lawyer that there are always exceptions to the rule. But I don't know, even on this court, that I would disagree that generally we don't know. None of us like to get opinions that are 50. But if you got a six consolidated cases, it may be 50 something pages.
Right.
So anyway. But I take your point. I think that's well taken.
You were mentioning that you consider yourself a textualist, which I believe by that you mean you look at the literal words of the statute as enacted by the legislature and try to be faithful to that. We see in many opinions the statement often repeated that the appellate courts are to presume that the legislature was aware of other laws when it passed a law,
right,
and that it knew the consequences of passing a new piece of legislation and took into those other laws that may be in conflict with it at the time it passes a new piece of legislation. I'd like to hear your thoughts about that and whether. Is that true? Is that what appellate courts do? Do they really say, well, the legislature, which by the way is only consist of less than 20% of the legislators are lawyers? Do appellate courts really think they know what they're saying and knew about the other laws when they pass a new law?
It's a fiction. It's like a canon of construction that we basically we assume that the deliberative process, that I shouldn't say it's a complete fiction. It is a presumption that we do as I think as part of the separation of powers. It's a fiction only in the sense that we're not really delving into and saying, okay, is this really going on? We don't do that. We simply say, we presume this is what's going on, because I think to do otherwise does get into some separation of powers concerns. But you make within the question you're asking is a broader statement. Words, one of the things you do as a textualist, and this is what the difference between a strict constructionist and a textualist would be. A textualist doesn't just look at words in isolation. So, if you're involved in a case, Robin, where you're dealing with kind of one specific statutory subsection, it may be that the rest of that statute informs the meaning of that statutory subsection. It may be that there are other statutes that have, if it's very kind of unique, specific language, it may be that there are other similar statutory contexts where that phrase or that language has built up a meaning in another context that may or may not be relevant in this context. So whenever you talk about textualism, context, I think I said this in a concurrence once, in life and law, context is crucial. So we don't ever analyze things in isolation. We analyze them in context. We analyze them also in the context of precedent. What has the Supreme Court maybe done in similar context? How have they interpreted similar language? We may look in some cases, if it's the evidence code, to what they even say in that the new evidence code, we're to look at the decisions of the 11th Circuit, setting aside whether they can bind us to that, whether that's a separation of powers issue. We do it. And the Supreme Court of Georgia said we do it. So we'll look at those. And then you've got things like you mentioned, things that I would call presumptions or canons of construction, things we look at. So, it's not simply a matter of just saying, I'm only going to look at what these words mean in this sentence. It's a matter of interpreting it holistically and as a whole, and even looking sometimes at the statutes which were replaced by the current statute, because when language is taken out, that's different than legislative history, right? Legislative history, as we commonly refer to it, might be somebody on the floor saying, this is what I think the law means. That's a very different animal than statutory history, where the predecessor statute said, you've got to send this to the Attorney General. And then in the new statute, it doesn't say that you have to send anything to anybody. And prior cases say, oh, you got to send it to the attorney general. Well, that was taken out. The fact that it used to be in there and now has been taken out, that may be relevant in how we interpret that subsection. So there are a lot of moving pieces to statutory construction. And I know you know that. I know Lester knows that. So like I said, I don't know. The older I get, the more I don't mind. I'm not running away from the textualist label, but I think it's important to educate about what that means. And, Elena Kagan is a textualist. She'll tell you that. There are different types of textualists, and we don't always agree on what the meaning of the words that are before us. But I think it's important for a judge to try to operate, like I said, within those parameters. That language only goes so far. And so the question is, are you fairly interpreting the words that have been passed by the legislature and acted into law? Are you fairly interpreting those words? And are you using neutral principles to try to get to the right answer or the best answer?
I love your opinions about that and how you see things like that. And that you named a liberal textualist too.
Listen, I love Kagan. I'll just tell you, I am unashamedly I don't always agree with Justice Kagan, but man, you want to talk about somebody I'd love to get a beer with. She is, I think, if not the smartest person on the court right now, she's one of the smartest people on the court. And she is, if not the best writer on the court right now, she's one of the best writers. I mean, I love her writing style. I really just think she is. And you know what? She wasn't a judge before she was appointed to the Supreme Court. Was not a judge, and she's been remarkable. That's
a whole nother conversation that I did not put in our outline about.
Yeah. I'd throw that out there.
Qualifications of a judge, whether they should have struck a jury before. And we've had that conversation, I know. And I know you have struck a jury before.
Not as many as you and Lester, but I've handled, I've had several jury trials and many things awful close to that. So
sometimes Lester and I talk to each other about that. That's kind of our standard bearer right there. Have you ever struck a jury? That's what we want to know.
Well, and it's funny because like, I remember talking to one of your colleagues, Judge McFadden, one time. And, I've always said a Westlaw, any Westlaw search will reveal that I'm the crappiest appellate lawyer in Georgia. But I was talking about, I don't really consider myself an appellate lawyer. And Judge McFadden said, well, how many appeals have you argued? And I said, I think about 35, or 40, something like that. And he said, that would put you in the top, I don't know, whatever percent or whatever. But it's interesting to me, when you talk about, and some of these things we're talking about, there's the question, and you touched on this a little bit earlier, but whether they are prescriptive or descriptive. And I think we've gotten into this with a lot of, public policy type things. It used to be that you might use conservative, we'll say, to describe Barry Goldwater, maybe liberal to describe Ted Kennedy, because you looked at the conglomeration of their political votes and you said they fit into this camp or they fit into, one of the other camps. And it seems to me with judges, and a lot of this with talking about what your judicial philosophy is and that kind of thing, when people ask that in confirmation hearings, they're kind of asking it like, we want you to prescribe, we want you to tell us what this philosophy is, because it's going to prescribe, not describe what your judicial style may be.
Right.
And and particularly when you talk about Justice Kagan, who I agree has a great writing style that comes across very plain spoken, but not cutesy, but she's an academic. So we have sort of academic influences, and they try to characterize that sort of thing about a judge. So have we, are are we really trying to get judges now? Do you think it's a danger that we try to get judges that have a philosophy that prescribes what the outcome is going to be instead of just sort of describes the process that they go through like you've done with us today?
Yeah, I mean, I think the problem that I've seen, and I'm always a little bit amused by the fact, this is a whole nother podcast about how people decry, what Georgia does and other states do in electing their judges. I always say that I think Georgia has the best system of that because of the nonpartisan nature. And we also benefit from having an incredible bar that has been vigorous in defending the independence of our state judiciary. But the idea that the federal process is somehow this, enlightened, apolitical. I mean, you can watch both sides, regardless of, going all the way back since I've been following it from President Reagan on to all the way through. And you can tell when a lot of these candidates, these folks that are offering themselves up for public service, just like we have now under the Biden administration, when senators are asking them questions, they don't care what their answers are. They're trying to trip them up. They're trying to put them in a box. They're not really interested in letting people. They're not really interested in letting people explain what their views are, or having a nuanced conversation. They just want to put them in a box and say, this person, I consider this person to be a conservative or Republican judge, and I consider this person to be a liberal or a Democratic judge. And I just think that's unfortunate. I think those Senate judiciary, wouldn't it be nice if we had a Senate Judiciary Committee, regardless of whether it was controlled or headed up by a Republican or a Democrat, that had the kind of conversation that the three of us are having today? I mean, wouldn't that be nice to have a really honest, frank conversation about, and look, I learned from different judges and different approaches to the law. I've changed aspects of and refined aspects of my jurisprudence. I don't think you should ever be stagnant. I think you always ought to be critically examining. I like to read articles from people who are critics of originalism and textualism, because I want to hear what other people have to say. I want to always be open to thinking in a deeper way about my job, because I think I owe the people of Georgia that.
I think that's a wonderful stance to take, Judge Dillard. I wish all took that stance. I think it says a lot about you as a judge that you are like that, and that's the position you take. We've taken so much of your time. I want to ask a couple other questions though before we go to the final question.
Sure.
That we're going to ask, but I mentioned in your introduction that you're a member of the Catholic Church. I know personally that your faith means a lot to you, does to me as well. Can you talk a little bit about putting that in context, that, when people hear that a judge is a Catholic or a judge is whatever of a particular faith, everybody all of a sudden gets really nervous, like, oh goodness, it's going to be a Catholic opinion or something like that. How does your faith influence the way you see your job, the way you perform your job?
Yeah, I think it influences certainly the way I treat people in the workplace. For me, a central tenet of my faith is that every human being has inherent dignity and worth. My faith doesn't dictate how I rule in cases. In fact, I've explicitly ruled against the Archdiocese of Atlanta in the case. I've ruled against my own church. I've ruled against my own mayor. I've ruled against a lot of my friends. My faith doesn't dictate, but I think where things like that, like my faith and my background, I think come into play. How I was raised by my mother, a single mother who, dedicated her life to social work. The values she instilled in me, it comes across, I think, in how I write. And I don't think there's anything wrong with that. I think I have it's probably not for everybody, but I think I do have a unique writing voice. And I think, when I talk about the idea of, I'll give you one quick example. When I had the Richard Jewell case, that was one of the first big cases I had. Ultimately, we ruled against Mr. Jewell. He had passed away at that time, and it was his estate. And at the very end, I wrote a little concluding paragraph talking about his heroism, and basically said, notwithstanding everything I've just said, I want to take a moment to talk about the fact that what happened to him and what he went through wasn't right. And that this person, went through something extraordinary and saved a lot of lives because of his heroism. And I didn't have to do that, but I felt obliged to do that. This is somebody who had already died, somebody who had saved a lot of lives. And at that moment was the right person in the moment. And so I wanted to acknowledge that. And I don't think there's anything wrong with that. It didn't impact how I decided the case, but I always, you ask me how it influences in me that when I'm reading briefs and reading cases, I'm not looking at paper, I'm looking at people. Even if I don't see them, I recognize that every case involves real people and real lives, the lawyers' lives, the clients' lives, their families. And I don't take that lightly. And so that's to me how my faith, it impacts how I write. It impacts how I treat people. It doesn't have a thing to do with how I decide cases. So I would hope that people that are concerned, would think those attributes are the kind of attributes that they would want in a judge, regardless of whether they called themselves a person of faith or not. I like to say that I'm a practicing Catholic because I need all the practice I can get.
Well, we certainly appreciate all your time today, and Judge Dillard, and you're taking time out. Especially, I didn't realize when we scheduled this that it was going to be in your distress period, so I apologize about that. But
no
thank
worries.
you again. But our last question that we ask every guest.
He won't be the first. He won't be the first guest we've left in distress, Robin.
Right.
Our last question to every guest is, what is your definition or your notion of justice?
That's a great question. I think we could have an entire podcast about that. For me, it goes back to some of what I said earlier, but I do want to say this. I care very deeply about access to justice. I think a lot of the cases that are going on in Georgia state courts and in state courts across the country are pro se people. I don't know that our legal system does the best job of empowering and enabling people who are socioeconomically disadvantaged or don't have the means to really represent themselves or deal, with certain important legal matters. I think courts can and should do a better job of how we deal with those folks, because, a lot of people say the system is really built for lawyers and not clients and not real people. And so I think for me, a lot of justice, I hate to be real practical with this, but that to me is kind of something that kind of cries out for, as a profession, for us to continually seek to do better there. I think justice to me is going back to, in my view, as an appellate judge, justice means that a lot of justice should take place at the trial level. I think that's really where you have real people, witnesses, cross-examinations, a jury of your peers. I think you both know, and I say this as an originalist, I am a staunch defender of the right to a jury trial. And in Georgia, I think we have even a more robust right to jury trial than we do at the federal level. We say that the right to jury trial in Georgia is inviolate. And I think Georgia historically has, and I think our founders historically cared very deeply about the right to a jury trial. That, to me, a lot of justice is, it may not be sexy to talk about process, but process matters greatly in terms of ensuring justice. And then in terms of my judicial philosophy, once again, I think for me, justice means applying the same approach in every case to every person, regardless of their background, who they are, what their socioeconomic status is, race, gender, you name it, anything you want to name. I want every person that appears before my court to have confidence that they are going to be given fair treatment, and we're going to have deliberate consideration and thoughtful consideration of their appeal. Even if they don't agree with it. The greatest praise anybody can give me is if somebody walks up off the street. I've had that a couple of times, not so much clients, but lawyers, and they say, you ruled against me, but I understand why I lost. I don't, you explained it, and I understand why you did what you did. And I want people to have faith in the process that I use as a judge, that my court uses to come to our decisions.
That would be a high compliment indeed, to have the loser attorney say, I understand.
But it does happen every once in a while.
Well, thank you, Judge Dillard, for being with us today. Again, for our listeners, we've been talking with the Honorable Stephen Dillard, presiding judge of the Georgia Court of Appeals. You can learn more about the Court of Appeals and watch those oral arguments that are online at gaappeals.us. And I encourage everyone who's listening to watch one of those oral arguments. I think you'll learn a lot, and I think they're very, very interesting. Thank you again, Judge Dillard.
It's been great. We could have gone on and on, I think.
Absolutely. We'll do it another time. And please,
I was going to say, I think we need part 2, because we didn't cover half of what I wanted to cover. But
please come to the new courthouse. The people of Georgia, this is your courthouse. Please come and see it. It's beautiful, and I think something that all Georgians can be proud of.
I agree.
Great.
All right. Thank you.
Thanks, y'all. Take care.
Bye.
What I have today is not really a news article, although it may subsequently be written up, but it involves a letter that was written by a number of Yale Law School professors in response to the ABA, some proposed new ABA standards, and they have a lot to say about different ABA standards. I want to concentrate on just one of those, and that is they're responding and complaining about proposed standard 206A1, which requires, proposed standard 303B3, which deals with curriculum, and it requires law schools to provide substantial opportunities to students for the development of a professional identity. And a professional identity focuses on what it means to be a lawyer and the special obligations that lawyers have to their clients and society. The development of professional identity should involve an intentional exploration of values, guiding principles, and well-being practices considered foundational to successful legal practice. And so in criticizing this new requirement that the ABA Council on Legal Education wants to impose, these Yale law professors say, first, that to the extent that matters of this sort customarily arise in professional responsibility courses that are already mandated, the requirement's redundant. But then they go on to say, and I'm quoting this group of law professors, supposedly some of the smartest legal scholars that we have anywhere in the United States. They say, and I quote, law schools do not ordinarily command expertise about the practicalities of law practice and should not be pressured to develop such a field. That just left me sort of speechless. And one of the reasons they give for this is that they say we have a diverse student body, and some of them do not intend to maintain a successful legal practice. Well, if you don't, there are people who go get professional training, and yes, they go into something else. I've got an industrial management degree from Georgia Tech, and I've never managed an industry in my life. It was a stepping stone to something else. But to say that they shouldn't have trained me in industrial management would be just bizarre. And the idea that we have 12 professors, I think it's 12, I'd have to recount there, who would actually, and as we've talked with Judge Dillard today, words really matter about stuff, would say, our law school, we're really not teaching people to practice law, I find just sort of laughable.
Yeah, I had not heard about that. We probably ought to put that letter up on the on our website. It's hard to understand. There's a lot of theory, obviously, in law school, how to think like a lawyer and all that. But also, you're about to step out and represent real life, walking around people. You better know. You better have been taught how to do that.
I was just thinking, like, can you imagine a medical school, a group of medical school professors writing back? And people go to medical school for reasons other than that they want to go be clinical doctors. But as far as the training and the curriculum set, can you imagine them writing back a letter to some medical school council saying, we just don't train people to be doctors, and we don't see any need, and we don't think we should be forced to train doctors. I just find it bizarre. Very.
My story is more on the humorous side, and it's an article I came across, and it happened in Michigan, in East Lansing, Michigan. Fortunately, not a Georgia lawyer, but the title of the article is "Lawyer Finds It Very Expensive to Flip the Bird." And we're all doing our Zoom hearings these days. We talked just now with Judge Dillard about online Zoom appellate arguments. And this was an appellate argument in East Lansing, Michigan. And a lawyer who had tried the case below, but was just watching the appeal, had another lawyer arguing the appeal, apparently used his middle finger to express himself during the oral arguments. And the judges saw that. He was saying, like, vote for us. We're number one. We're number one with that finger. The judges took it as an obscene act, using his middle finger during the oral argument. They confronted him about his behavior, and he claimed he was merely pointing at his broken computer. The excuse did not fly with the judges, and they said that this lawyer exhibited shameful disrespect to the court and to opposing counsel in his offensive gesture and his dishonest replies to the court's inquiries. And they fined him $3,000. That lawyer says, "I've been a lawyer for 46 years. I've never been accused of inappropriate, unruly, or rude conduct in a courtroom." But he went ahead and wrote the check. So it doesn't pay to show your disapproval or disagreement with an appellate court on Zoom. Certainly not in East Lansing, Michigan.
That's very, very interesting. Not the kind of thing, I guess, that dissents are made of.
No, but we were talking before we started taping about all the crazy things we've seen and heard of on Zoom, and that's just another one of them.
It's it has really, in a lot of ways, the things that have happened on Zoom in these online court hearings, and there's a whole set of them out there. But I think one of the things it's been useful for is a lot of the people doing things in these Zoom hearings were just doing these things in court, and nobody except the lawyers that are sitting around waiting on their case to be called or waiting to argue, in the jury box saw this happen before. And so now the YouTube public is aware of all of the things that made for great lawyer tales for many, many years.
That's right. That's exactly right. Well, Lester, that's all I have for today. Do you have anything else?
I don't either. And I guess we will see you next time. Next time we'll see you in court.
Thank you for listening to See You in Court. Brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Fraser Clark and Lester Tate, until our next episode, we'll see you in court.